All right, welcome everybody. Good morning. Good morning. I am so glad to have you with me. This is the 2024 Georgia Association of Realtors, or GAR, contract changes. So today's class, this is not a full-blown contracts class. It's not a purchase and sale agreement front to end. We teach those classes later on in the year, starting in February or March. We call those 2024 GAR contract dissection. Today's class is just on the changes that the Georgia Association of Realtors Forms Committee has made to the contract package from 2023. In addition to that, GAR, their forms committee, they meet throughout the year, but they also put out a set of changes mid-year, and typically those changes just correct typographical errors, syntax errors, punctuation. Every now and then they'll make some pretty substantial changes. Since most agents generally just take a new contracts class the end of the year or the very beginning of the next year, a lot don't take a class after those mid-year changes come out. So the reason I'm telling you that is today's class, I am also going to start off by covering the mid-year changes that GAR made to the contracts in June 1st of last year. So welcome everybody, settle in. My name is Dana Sparks. I am the broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America, which is the entity, the school offering this course for CE credit. This class is, I forgot what I started to say. In any class that I teach, my goal is that the 3 hours goes by really quickly. I promise we will take a break. I talk quickly, but we will take a break. And that the bonus to you is that you got the 3-hour CE. This is always a really fun class for me to teach because unlike some others where you have to be there, like license law, you don't necessarily want to be there, you have to be there. This class I typically find is people that want to be here because you want to learn about the changes. So welcome. I see a lot of old friends, so good to see everybody. And I see a lot of new faces. So if this is your first time taking a class with me, or a first time taking a class through our school, the Real Estate Academy of America, I hope you enjoy yourself, and I invite you to take additional classes throughout the year. So we will get started. The way that I am doing this, I have a PowerPoint and I have the actual forms. I'm going to flip back and forth because in the PowerPoint, I have copied and pasted. I have an excerpt of how it read in 2023 and juxtaposed with the changes they made in 2024. I also have just the 2024 forms underlined with all of my notes. These handouts are not required for the class, but they are available for you as a reference. I'm going to put it in the chat. But you just go to www.eagentweb.com. You'll find a tile that says training videos. Click on that and just scroll down the page for this class, and you'll see hyperlinks to all the PDFs that we're going to talk about. And one of the hyperlinks is actually these slides. So I am going to dive in and get started, and we will go from there. So I'm going to get started with the actual PowerPoint, and I guess I should share my screen. All right, let me get out of this. It helps if I share the screen first. All right, here we go. All right, and if you have any questions, please feel free to type them in the chat. I do have the chat up and open so I can see your questions. All right, today's class is the 2024 GAR Contract Changes. It is GREC course number 77054, hosted by Maximum One Realty Companies, but offered through the Real Estate Academy of America. I am the instructor, and there is my contact information. Notice to students for the virtual broadcast of a CE class that is a GREC approved classroom class. Our school, Real Estate Academy of America, renews in 2026. And this class is for 3 hours of CE credit. I am your instructor. No homework and no written exam. The way we do attendance through our school for virtual classes is through the chat function. So if you've already done so, you do not have to do it now, but I will ask you 3 times to interact with the chat with your name, your real estate license number, your email address. We ask for your phone number just because sometimes we have found through the years recording CE credits that some agents don't necessarily know their license number or accidentally transpose numbers. And we need to be able to contact you in order to give you credit. And sometimes the email address you give us is an email address that you don't necessarily check on a daily basis. So we just want to make sure that we have a way to contact you should we need to. Students may only receive credit for a specific course number once every 12 months. If you've already received credit for this course within the last 12 months, you're invited to attend but won't receive additional credits. That's with any CE course. You can take 3, 4 more courses on the GAR contract changes from other instructors through other schools, and you will receive CE credit. It just has to do with that specific course number, not course topic. And of course, as in any CE class, there is no recruiting. If so, contact GREC or myself or the coordinator of our school, Heidi Kelly. Heidi is the one that does record the CE credits, and she should have those done within 3 to 7 business days. And that is her contact information at the bottom of this slide. Additionally, for attendance, while I'm still on this slide, I will ask questions and go ahead and type in your answer in the chat. Even in the interest of time, if I have gone on and given the answer to that question, go ahead and type in your answer, because we use the chat as a cross-reference with the Zoom registration links and attendance links. Should any questions arise, to be able to demonstrate that you were attending the class for the entire time. Okay, we're going to dive in. So, how do you get the GAR contracts? Well, they have a licensing agreement. And if you are a realtor, then you have access to the GAR forms at no additional cost. You just need your NRDS number that you would enter into whatever entity it is where you access your forms, whether that be in Remind Docs Plus through FMLS or Transaction Desk through Georgia MLS. I'm not as familiar with .loop, so I'm not sure how they do it, but typically you would need your NRDS number. If you are not a realtor, you may pay Georgia Association of Realtors for the licensing agreement to use the forms for 2024, and it is an annual cost this year of $264. That cost does not get prorated. So if you're not a realtor, I suggest you go ahead and pay that now and have access to the forms the entire year. Because if you choose to pay and want them in October, you're still going to have to pay the $264. They are available online through, again, whichever service where you access your forms. They will be available January 1st, 2024, or even through GAR's website. Once they are released, it is a GAR licensing violation to use forms with any previous dates. And the penalty might be that GAR would revoke yours or your broker's license to use the forms for a specified period of time. Now, what does that mean? That does not mean that if you already have a contract, let's say you have a property under contract, you do, once it turns to January, you do not need to go back and rewrite that contract on a 2024 form. If you have a listing agreement signed already with a seller or a buyer brokerage agreement signed with a buyer, you do not need to go back and re-sign a brokerage agreement. Now, you might want to based on the changes they've made in those forms, but that's not what it means. What their licensing agreement means is that any forms that you need, that you would initiate after January, needs to be on a 2020 form. So some agents and some brokers will download the entire 2023 library. And we've had some contracts where some agents have used forms back from 2015, and that is a GAR licensing violation. So the public, of course, can use whatever forms they choose, but you as a real estate agent paying for the license to use the GAR forms, that is a prohibition of the agreement. And again, if you are a realtor, you will have access to them in January, again, via your NRDS number, if you are in good standing with your local board, and if you have fulfilled your NAR Code of Ethics. For you realtors, the cycle 7 ends December 31st of 2024. So if you have not taken the ethics class from January 1st of 2022, you will need to take it by the end of 2024. If you do choose to pay GAR to license their forms, you'll receive what's called an FPID, which just stands for Forms Purchase ID Number, and that versus your NRDS number is what you will use in whatever system you're using to access your package. The other alternatives are, if you are a co-op agent in any transaction, then the other agent can share with you the forms. Co-op agent meaning your signature is on the signature page in a transaction. If you are if your signature is not on the signature page, then you can't use them. Your broker may not give you blank forms. So if your broker has access to the GAR forms and you don't, and you need a form, your broker may not just give you the form. Think about that. If all GAR charged were the brokers, let's see, how many brokers are there versus how many agents are there? Obviously, the number of agents is more, so GAR is going to charge by agent versus by broker. The one exception to that is you guys are all affiliated licensees with your broker. All contracts are written in the name of your broker. So if you need a GAR form and you don't have one and your broker does, you may use your broker's form for that transaction. However, if it calls for a signature, it must be your broker's signature on the signature line. And pre-printed on the forms below everything else in the footer, it does print the name of the person whose forms you are using. Additionally, there is the GAR website. It's garealtor.com, and National Association of Realtors website is realtor.org. If you are a realtor, you do have access to the GAR, Georgia Association of Realtors legal helpline. It is available. There's the link, and it is available also if you go to GAR's website. You'll see an access to that, but you do need your NRDS number to access that. All right. Other changes. GAR, Georgia Association of Realtors, always puts out whenever they put out their forms, anywhere you go to access, let's say, a blank purchase and sale agreement, a blank brokerage agreement, an exhibit, an amendment, they also have a couple of forms, well, lots of forms you might not be familiar with, but some specific to this class. They have an index of the actual 2024 GAR forms changes, as well as an index and an actual, all written out, all the special stipulations. Also, as I said, they do mid-year changes. So remember to check this because they'll do an index of the mid-year changes also. Make sure to check that in April or May of each year. Again, as I mentioned at the beginning, this CE class will cover both the 2023 mid-year changes, just the major changes, along with the major changes to the 2024 GAR package. All right, so again, this is the mid-year changes that GAR made June 1st of 2023. They modified 20 forms. This is just a list of the forms that they modified. I'm not going to cover all of the forms. Again, a lot of these were syntax or for continuity, spelling errors, grammatical errors, so forth and so on. But I am going to cover some of the major changes. Also, again, wherever it is you access your forms, whether it's Remind Docs Plus or Transaction Desk or Dot Loop, you also have availability to look at the outline. And this is the revisions package, and you'll see it says the following pages will list the changes to the forms in the entire GAR form revisions package. This is what got a list of what got changed from the initial release of the forms dated 1/1/23. And it outlines all of the forms, and you'll see the date at the bottom, and it's teeny tiny, but it does say 6/1/2023. So you'll see sometimes it's just a rewording or it's all capitalized. But again, I just wanted to show you where you can see each and every change. Like, for example, estimated net to seller. They corrected number 23 to 22. I'm not covering those changes in this class. To the brokerage agreements, nothing major got changed. They reworded hazardous conditions on the property. And you'll see when we get to the 2024 forms, they also even went a little bit further with more explanation and disclosure regarding hazardous conditions. They just changed the protected period, not the time frame, but just some of the grammatical changes, so forth and so on. But let me tell you what they did under hazardous conditions. And this got changed in all of the brokerage agreements. Under this section, they reworded it and capitalized it. And it just says, seller acknowledges that broker has no duty to inspect the property for defects, hazardous conditions, repairs, or any other matter. Seller owes a duty of reasonable care to keep the property safe for prospective buyers and their agents, invitees, and contractors who view and or inspect the property. This duty includes a duty to warn all such persons of dangerous conditions that would be obvious to such persons. To minimize the seller's potential liability, seller is encouraged to correct all hazardous conditions on the property. Seller agrees to indemnify and hold broker harmless from and against any and all claims, causes of action, suits, and damages arising out of or relating to a person or persons being injured or harmed while on the property. They did the same thing in the buyer brokerage agreement, but the verbiage is that the buyer acknowledges. And especially we've had a lot of out-of-town buyers, and a buyer and a seller will have negotiated for some repairs. The buyer is out of town, and they ask the buyer's agent to go check on the repairs. Have the repairs been done? And so this verbiage protects you, agents, and your brokers from any liability regarding these kinds of issues. Under the authorization to show unlisted property, they added this same hazardous conditions issue. And on that form, we know that a brokerage agreement turns that public person into a client of the broker, and the broker then has a fiduciary responsibility to that public person who signs, either buyer or seller, who signs a brokerage agreement. The authorization to show unlisted property describes the customer relationship between the public seller and the broker. And likewise, the customer acknowledgement describes the customer relationship between the public buyer and the broker. And the duty is ministerial acts. Now, you still have to be open and honest, but you do not have that fiduciary responsibility. By default, any public person with whom you work is a customer of you and your broker. They only become a client regardless of past relationship or if they've been a past client. For any one transaction, they only become a client once they sign a brokerage agreement. In Georgia, the client relationship is contractually driven. So what does that mean? That means if you're working with a past client that you've done business with before repeatedly or however often, and they find a new property and you're going to work with them on a new property, they are your customer regardless of the information you know about them until they sign a brokerage agreement. Now, you would have to disclose that they, in the material relationship, you have a material relationship with them by virtue of them being a past customer, past client, but they're not a client for this transaction. Why am I telling you all that? Because I can't help but teach on a topic when I'm here. But specific to the June 1st, 2023 changes, the authorization to show unlisted property is the document that describes the customer relationship with a public seller and your broker. And it said no brokerage relationship. It used to say between seller and broker, and they changed it to owner and broker because that person that owns that property might not yet sell it. All right. So everywhere it said seller, they changed it to owner. Under the buyer brokerage agreement, same thing. They did the hazardous conditions and that hold harmless language and limits a broker's responsibility. And also, when you are working with a buyer as a client, so this is a public buyer who has signed a buyer brokerage agreement with you, they added in where it says that the broker, and everywhere, just so you know, it's elsewhere in the contracts. Every time GAR uses the word broker, by extension, it also means you, affiliated licensee. So you can use those terms interchangeably. But it says buyer acknowledges and agrees that broker may show properties in which the buyer is interested or in which the buyer has made an offer or a counteroffer to other prospective buyers and assist other buyers in making offers and counteroffers on such properties. In other words, you can work as a client with more than one buyer, and they may be interested in the same property. And every buyer acknowledges that they all acknowledge that you can work with more than one buyer, even if they're writing an offer on the same property. And again, it says you as the agent and your broker have no duty to inspect the property or advise the buyer on any hazards, so forth and so on. That paragraph had been there. They just added the hazard part to it. All right. And then again, as I talked about under the hazardous conditions under the seller brokerage agreement, they added it in the buyer brokerage agreement. And just so you know, they also added the same information in all caps with the hold harmless statement in the purchase and sale agreement. These are the changes to the purchase and sale. And basically what it said, they added a thing, a phrase in the under the title insurance. And it used to say, it says that buyer hereby directs any mortgage lender involved to quote cost of title insurance based upon the presumption that the buyer will be obtaining an enhanced title policy. It used to say, since such policy affords buyer greater coverage. June of last year, they changed the verbiage to say, if such a policy can be issued on the property or for the buyer in this transaction. So just a slight change in verbiage. And then they changed the purchase price. So at closing, the purchase price shall be paid in US dollars. And what they have added is in any method of delivery acceptable to the closing attorney, including but not limited to wire transfer. So there are some attorneys in Georgia that accept additional forms of the money for the purchase price. And so GAR just added that in to the purchase price section. In the closing costs section, not a ton of changes, but it was all there, but it was all in one big, huge paragraph. And so in June of last year, they separated out the closing costs section to clarify the language for easier understanding. So they separated out into the seller's contribution at closing, additional items paid by the seller, items paid by the buyer, proration, so forth and so on. It had all been there. They just made it easier for people to read instead of reading one big long paragraph. So everybody hopefully is on the same page as to who is paying what with respect to closing costs. Now, a change they made in January of last year, but in light of everything going on, I want to point this out while we're here because this is still in 2024. In this closing cost section, in paragraph A, where buyer and seller negotiate that a seller will pay X amount of dollars towards a buyer's closing costs, it does say at closing, seller shall make the reference monetary contribution which the buyer may use to pay any cost or expense of a buyer related to this transaction, including without limitation any commission obligations of the buyer. So that's going to be important this year moving forward. Again, GAR made that change last year. Not a change. Just want to point out that in the GAR contract, a seller's contribution to the buyer's closing costs may be used for prepaids, escrows, any of the lender required costs to close the loan, and any commission obligation that the buyer may incur. If the seller had contributed, made a contracted to contribute more, if there's anything that the lender cannot use towards those obligations, it does say any unused portion of the contribution remains the property of the seller, meaning it will go back as a credit to the seller on the closing statement. Okay, now with the disbursement of earnest money, so hopefully everything closes and the earnest money gets dispersed at closing as a credit for the buyer that they've already put in earnest money into the deal. However, If a contract fails to close, if there's a termination and buyer and seller sign in agreement regarding how the holder disperses the earnest money, the release part of the TNR, then the holder disperses the earnest money as directed by the agreement between the buyer and the seller. However, if a buyer and a seller don't both agree to the disbursement of the earnest money, if one of the parties does not sign the release portion of a TNR, then the holder may do what we lovingly call the 10-day letter. What that means is the holder gets to interpret the contract and the reason why it failed to close and make a decision based on the contract and what the parties had agreed to, who gets the earnest money. Now, just so y'all know, because we're here, if it is an all cash transaction and the closing attorney is the holder of the earnest money, the closing attorney may not do this contract interpretation. The closing attorney in an all-cash transaction, if the closing attorney is the holder, must send it to court in an interpleader action. Let a judge decide. So there is a lawsuit, legal fees, so forth and so on. That's in an all-cash transaction, closing attorney as holder. In a if there's a loan and the closing attorney is the holder, or either broker is the holder, one of the options that the broker or the holder may do is interpret the contract and send a notice to both parties how they intend to disperse the earnest money. And the party not getting the money has 10 days to make a contractual objection. That's why we call it the 10-day letter. We can't disperse it we have to give the party not getting the money at least 10 days. So in doing that, in making an interpretation and trying to figure out what happened, why it didn't close, what amendments had been signed, because the holders might not have copies of all the amendments, so forth and so on. What they added in June of last year is what I have underlined here in red. Any party, real estate licensee, or any other person having knowledge of or an interest in the disbursement of the earnest money may object to or provide information regarding the proposed disbursement by giving written notice of the same to the holder. What does that mean? That before, it was just the buyer and the seller were the only ones that could offer information or lobby a written objection to the intent. But as you guys know, a lot of times the agents have a better overall picture of the course of events and what transpired that prevented this from closing, or a lender or a closing attorney or a broker. So GAR's just added in that anybody that has knowledge that could help with this decision of the disbursement may, in writing, contact the holder with that additional information. All right. Under the, again, continuing on with the June mid-year changes of last year, under the inspection and due diligence period, from the time the parties go under contract through closing, the seller is required to allow the buyer and or buyer's representatives access to the property, again, through day of closing for final walkthroughs, so forth and so on. And what they added was this last phrase that said that the seller has to make the property available for utilities, systems, equipment, and all that to be on, blah, blah, blah. And then they added, and all parts of the house to be accessible, including basements, attics, and crawl spaces. What was happening is buyers and sellers were going under contract. Buyer would have their inspections done, appraisal would be done, and then the seller starts packing and loads up the basement or the crawl space with boxes and boxes and boxes, making it very difficult for the buyer to do a walkthrough or check on repairs or just check the status of basements, attics, and crawl spaces. So they've added that in there. And under this section that is all, it's a little bit tricky to see on these slides, but this is all in bold font. Buyer's inspection indemnification obligations. The buyer agrees to hold the seller and all brokers harmless if anything from suing anybody based on injury, damage, so forth and so on from any inspections. And what they've added at the bottom is this indemnification obligation shall not apply to damage resulting from defects in the property uncovered during the inspection period. So if there was already damage there and it was just discovered during the inspection, that does not hold. And they have just clarified what designated agency is under the agency and brokerage section. So we agents and brokers always knew that it's one broker, two agents. Each agent has a brokerage agreement or a client relationship, one agent with the seller and one agent with the buyer. We all knew that, but the public did not know that. So GAR just added this sentence defining what designated agency is so that our public buyers and sellers understand. Again, we're in the purchase and sale agreement. So it says if the broker in this transaction is acting in a designated agency capacity, and here's where they added the definition, where one licensee of the broker is exclusively representing the buyer and another licensee of the broker is exclusively representing the seller. Always been the case, just defined it for the public. Under this disclaimer section, where this paragraph completely, the intent is to protect you licensees and brokers. And it basically says, okay, buyer and seller, we are brokers and we are agents, and we are acting within that capacity. We fill in the blanks on an attorney prepared contract. We are middle level management. We manage all the various parts, but we are not the expert in any of those parts. We hook you up with inspectors. We give you a list and you have a choice of inspector. We give you a list of warranties. We give you that. We give you a list of surveyors and you choose that. If you have any question about zoning or the contract or the value or title insurance or utility bill or termites or anything, the burden is on you, buyer and seller. Buyer, obviously, to check out the property. Seller, because you want to make sure you're protected in the contract. And we can't tell you, ooh, this is going to be a good value or you're going to net X amount of dollars, because we don't know what tax liabilities you may or may not have. So basically, this has been a flood zone. Check with your hazard insurance, so forth and so on. This paragraph has been in here and reworked by GAR throughout the years to protect you and your broker. What they added mid-year last year, it says buyer and seller acknowledge that the broker does not perform or have any expertise in any of the above tests or inspections and reviews. In other words, if an inspector goes and inspects the report and inspects the property, sends you a report, we're not the quote unquote expert, even in reviewing any of the reports provided to you by the professionals above. And again, this is just for legal protection for you guys. This is if one of the parties defaults, the rights of the broker. It just says the defaulting party shall pay as liquidated damages to the broker in this transaction the commission the broker would have received. All right. Then one of the things that under the definitions section, here's where it says broker shall mean the licensed Georgia real estate broker. the actual company, the brokerage firm, and their affiliated licensees. So again, you don't have to worry if you're an affiliated licensee. You are protected every time the GAR contract refers to broker. And you brokers, it doesn't necessarily mean you as the qualifying broker or managing broker of a firm. It also refers to the entire firm or company in and of itself. Additionally, they have added the definition of client versus customer, which is what I already addressed to you guys in this class a little bit earlier. A client shall mean a party who is being represented by a broker pursuant to a written brokerage engagement agreement. The term customer shall mean a party or parties who are not being represented as clients by the broker with whom the party or parties are working, for whom the broker may only perform ministerial acts. Agents, while I am here, just because a public person has chosen to work with an agent or a brokerage as a customer, the public person has still chosen that agent and that firm with whom to work. They have just decided that the legal nature of their relationship is that of customer versus client. What that does not mean is that does not mean that you on the other side of a deal have permission to quote unquote cross assign. In other words, let's say you are the listing broker, the listing agent, and your seller has signed a seller brokerage agreement. So you're working with the public seller as a client. You get an offer from a buyer written by an agent, and it indicates that the relationship between the buyer and the buyer's agent / broker is customer. That doesn't mean that you can immediately start contacting the buyer of this transaction immediately. There is still a brokerage relationship. It's just a customer relationship, but you still have to go through the agent to communicate with that public buyer. Other than notices, that's a whole different, we discussed that in the actual class, dissection class. But I just wanted to let you know that doesn't mean you can cross assign. And for our public, it does define what I've already addressed, client versus customer. Same changes they made in the lot purchase and sale agreement, same universal changes to the land purchase and sale agreement and new construction. In the temporary occupancy agreement for the seller after closing, what they have added here is this is you go to closing and buyer and seller negotiate that the seller is going to stay in the property for a few days after closing. So the property now belongs to the buyer. The buyer is on title, but the buyer has negotiated with the seller that you can maintain possession or temporarily occupy my home for a certain number of days, up to 60 days. And you have to be out on such and such date that gets negotiated in this exhibit. If you do not leave when you said you were going to leave, then you're not a quote unquote tenant. You are considered what in Georgia we legally call a tenant at sufferance, but you're not a tenant per a lease. Why do you not want to lease? Why don't we want to lease, especially for a buyer, for this temporary occupancy? The reason is because all of a sudden these Georgia landlord tenant laws kick in. We don't want that. This is just a contract agreement for temporary occupancy. But if the seller doesn't leave when they said they were going to leave, the new owner, who was the buyer, you still have to go to magistrate's court, file a writ of dispossessory, and actually go through the eviction process to get them out. And there are fees. This fill in the blank here is what the seller agrees to pay the buyer, new owner, per day for the amount of money that they say per day. But what they've added is if there is any damages, the seller will be liable for such damages if they fail to vacate when they said they were, including actual attorney's fees. So if the buyer / new owner has to hire an attorney to help them get that seller out of their home, the seller also, if pursued, is legally responsible for reimbursing the buyer for those attorney's fees. They just added that in. In the 8-day unilateral extension notice, under paragraph B, it used to say buyer's mortgage lender, including all cash transactions. They've just changed the verbiage to actually match that exhibit F401. And now it says buyer's mortgage lender, including in transactions where the financing contingency has expired. Just a few syntax errors and things like that. VA, for the VA loan exhibit, they've added that what they added, if you haven't done a VA loan in a while, in January of last year, they added that the termite letter, the initial termite letter, may be paid for. It used to only be able to be paid for by the seller. Now it may be paid for by the buyer or seller. So you guys don't miss this checkbox here if you are helping a buyer complete, if you're completing a VA loan exhibit. So the initial termite clearance letter can be paid for by buyer or seller. If, however, there is any damage done that has to be repaired and you have to get a follow-up termite clearance letter, that does have to be paid for by the seller. And what they've added mid-year is it must be paid for by the seller in addition to any closing cost contribution. So it can't be taken out of that pile of money allocated for closing costs. For you, with the buyer and the seller, negotiate to have the closing attorney as the holder of the earnest money in Form F510, which is the exhibit that the buyer and the seller sign, agreeing to which closing attorney is going to hold the earnest money. It used to say that the buyer had to get the contract to the closing attorney within 3 business days, and the closing attorney had to sign within 3 business days. They changed it to 5 business days. So they made that change in the F510, which is the exhibit that goes with the offer or the contract signed by the buyer and the seller. And Form F511 is not part of the contract. We see a ton of contracts where you guys are including this 511 as part of the contract. This has nothing to do with the contract. Buyer and seller don't sign this. This is only signed by the closing attorney, and it comes after your binding. It's not part of the contract. F510, this is the exhibit where the buyer and the seller do sign, saying who the closing attorney, agreeing which closing attorney is going to be the holder. This is the holder saying, okay, they asked me to hold it. I agree to hold it. Not all closing attorneys agree to hold the earnest money, but they added the same verbiage. They changed it from 3 days to 5 business days. If the closing attorney fails to become the holder, then it reverts to the alternate holder. But they just changed the time frame. This is my favorite change that GAR made mid-year on the termination and release. GAR has the termination of a contract and the agreement to release the earnest money. Those are 2 completely separate contractual issues, yet the Georgia Association of Realtors Forms has both of these issues on one form. It makes it very, very confusing because in a unilateral termination, you only need one, like a unicycle has one wheel. You only need one party signature on the termination. You do, however, need both sides of the contract signature agreeing to the release of the earnest money. But it used to have buyer and seller signature lines under the unilateral termination part, and it got very, very confusing. So now they have just changed it to one signature line. It doesn't reference if it's the buyer or the seller. It just says signature of party giving notice. They have two lines here in case there are two buyers or two sellers, so forth and so on. But again, it only takes one side to terminate, and the other side doesn't necessarily have to agree with the termination. The agreement is with the release of the earnest money. So this is very, very helpful. And again, this is the bottom of that form, and who gets the earnest money, you name the side, the name and the side and the buyer. Please put in the contact information for your holders. So in other words, you would put Jane and John Doe buyers with their contact information. And you do need both buyer side and seller side to agree. All right, that's it for the 2023 changes. And now let's dive in on to 2024. Woohoo! Happy New Year, almost. All right. Not a ton of changes to the residential purchase and sale or residential loan contingencies, the forms we use the most. There are some very important changes regarding commissions in the brokerage agreements and special stipulations. Stay tuned to the end because I will cover those special stipulations that I believe you guys are going to find very interesting. Other important changes, and as always, they also made typographical, grammatical, form number changes, and universal changes throughout similar forms. You guys know that. I'm not going to cover every form, but for example, if they made a change in the residential resale purchase and sale agreement, those universal changes are also evident in the lot purchase and sale agreement, new construction purchase and sale agreement, land purchase and sale agreement, so forth and so on. There are 4 new forms and 5 new special stipulations. So again, wherever it is that you access any of your forms, purchase and sale agreements, exhibits, amendments, brokerage agreements, so forth and so on, you also have available access to this document, which indexes all the changes that GAR made to for the 2024 forms package that they made from 2023. There are 10 pages of changes. I'm not covering everyone, or we would be here till the end of the year. But again, where you can get the handouts, I'll go ahead and put that in the chat one more time. One of the handouts that I have is a copy of this form as well as this entire PowerPoint. And the copies that you can download are also, they have all my notes on them, like here, new form, renumbered, so forth and so on. I mean, those were their forms, but these are their notes, but you'll see. All right, we're going to cover purchase and sale, a new form about assignment, the financing changes, loan assumption exhibit, sale or lease contingency, property disclosure, community association disclosure, both temporary occupancy agreements, agreement to reinstate contract. Great change they made there. That is not a new form, just want to put that in there. Brokerage agreements, referral, and the new forms, and the new special stipulation, and one consumer brochure. So hang tight. I'm gonna continue on. We still have more to go, so hang on. We will take a break, but not taking a break quite yet. So hang on. All right, this is where I'm going to switch between the PowerPoint and the forms. I'm going to switch because in the PowerPoint, I show what it looked like in 2023, so you can actually see in context the changes, and I think they'll make a little more sense to you. All right, so the first thing they did is it's so funny because this, under the closing law firm, it used to say closing attorney, then they changed it to closing law firm, and now in 2024 they're just going to cover all their bases and put both closing law firm and closing attorney. Why are they doing that? Well, the past couple of years we have had a lot of buyers and sellers moving to Georgia, buying properties, selling properties that are not from Georgia, and they have bought and sold properties throughout other parts of the country. And in many other states in our country, they don't close with a closing attorney. They close with an escrow firm or a title company, and they have an attorney that just represents their side and reviews the contract. So we here in Georgia, we talk about the closing attorney all the time. And sometimes it means a specific person. Sometimes it means a law firm. And if we name a specific person or law firm, it could be any attorney within that firm. So it got confusing for some people that weren't familiar with how we close real property here in Georgia. So GAR just tried to change that. So it used to say closing law firm. Now it says closing law firm / closing attorney in quotes, because as agents and brokers, that's how we always talk about it. The closing attorney, blah, blah, blah. And it just got confusing. This under earnest money is a very good change. Just helpful as a broker where we hold earnest money. It's very helpful to avoid having clients get confused or be out of compliance. So in 2023 and all the years before, where it talks about the earnest money, it said the earnest money shall be paid by check, ACH, cash, or wire transfer of immediately available funds. One of the things was check. Well, what does that mean? Is that a personal check? Is that a business check? Is that a bank check? What about a money order? Is a money order a check? Is a money order cash? It just got confusing. And ACH, a lot of holders, a lot of brokers and closing attorneys won't take ACH. So what they did for 2024 is they took out. And the other thing is sometimes agents would miss checking one of those boxes. So what they did is they just took out the actual form of the earnest money. And in 2024, now it just says earnest money will be paid to holder in a method of payment acceptable to the holder of immediately available funds. And this corresponding verbiage is in paragraph B7, where it talks about the holder of the earnest money. Same thing under purchase price. We already talked about this in June, where it said the purchase price paid in US dollars, method of delivery acceptable to the closing attorney. We just talked about that. In 2024, they're adding on to the end of that, and it just says that where this agreement refers to sales price, it shall mean the same thing as purchase price. Why did GAR make that change? I'm not 100% sure. Obviously, it has to do with some buyers and sellers, I guess, thinking that sales price and purchase price meant different thing. I guess because it's called a purchase and sale agreement, and it says purchase price paid by buyer. I guess sales price refers to the seller side, what the seller's selling it for, and purchase price refers to what the buyer's buying it for. I don't know, but they've just basically said those terms are interchangeable and mean the same thing. Now under keys and openers, let me do this. Let me show you guys the actual form. All right, so this is the actual list of all the changes. And you also in the handouts will get Let me make this a little bit bigger. You will also get in the handouts, if you choose to download them, again, a copy. I know I'm making you dizzy, but I just want you to see. You get a copy of all of the slides that we're discussing. But here is the 2024 purchase and sale agreement. There we go. So here's where it says closing attorney. Here's paragraph A7, where it talks about the earnest money and they removed the check boxes. Then here under purchase price, they put sales price is the same thing as purchase price. And then here under closing, so we're under the paragraph closing date and possession, where it talks about keys and openers. So they've done a couple of things. So what 2023 showed, 2023, it said at closing, seller shall provide buyer with all keys, door openers, codes, and other similar equipment pertaining to the property. That's all it said. In 2024, they have also added fobs, access cards, codes, and other similar equipment, allowing access to the property, the community, and community amenities. In the event the seller is required to return the above items to a third party, seller shall provide buyer with instructions on how to contact the third party to obtain. What on earth does that mean? Why did they add that in there? Well, a lot of these properties, the HOA, an owner, a property owner living in an HOA, let's say they have a swimming pool or a key fob or an access code, a code to a gate. It's a gated community, or a key fob or a card that allows you to access the elevator after hours or something like that. Well, some of these HOAs, the owner, if you sell your property, you are required to turn those key fobs, access cards, codes, so forth and so on. You're required to turn that back into the HOA. You are prohibited from giving those to the new owner, because the new owner will have to register with the HOA and get their own key fobs, key cards, so forth and so on. So what they have added, what GAR has added for 2024, is if the seller is prohibited from actually giving you something to access the house or the community, they have to turn it in. They have to provide you with instructions on whom to contact to get your own key fobs and access codes. So it makes sense when you think through it a little bit. Then a brand new paragraph, devices and fixtures. This paragraph states, except as set forth above, if a system, device, or fixture conveyed with the property cannot be operated without a specific controller, then not later than the time of possession, seller will provide the buyer with all controllers which are required for the operation of the devices. Seller will also provide the buyer with all device credentials, including but not limited to usernames and passwords for all devices, including access and guest codes, or the seller may reset those devices to factory defaults and provide the buyer with default credentials for all devices. Seller will also terminate seller's administrative access and any access granted to a third party. The cost of transferring third-party support to these devices and confirming that the seller's and or third party's administrative access is terminated is the responsibility of the buyer. Okay, my goodness. Woo, that's a lot. Why? And they've added this paragraph in everything. It's in the brokerage agreements and in the purchase and sale. Why? Well, with technology, there are a lot of sellers that have these smart doorbells, these all sorts of smart electronic systems, alarm systems, doorbells. My goodness, I just had new garage doors put in my home, and I could get an app and open and close my garage doors from anywhere by virtue of this app. And so what's happening is there's other parties that have monitoring systems. For example, if it's a security system or a doorbell or something like that, or there's more parts to it. Like there's the physical camera, let's say, as part that stays attached to the house, but there's a receiver or something else. So basically, because of technology and how our houses are so, you can do all kinds of really cool things electronically, what we've added into the contracts is that a seller is responsible for sharing with the new owner of the house how all of this stuff works. Number one, you have to leave all that stuff, including if you're leaving the Ring doorbell, you have to leave the receiver, for example, so forth and so on. So you have to not only leave everything that goes with it, but you also have to convey all usernames and passwords, terminate your administrative authority, share any third-party information, or restore all of that stuff back to defaults. So that's just, Nest. Yeah, there you go. Nest or Lemix thermostats is another one. Thank you, Beth. There's all kinds of things where you just have to be able, in other words, to let the buyer, who's the new owner of the property, know how all of this new technology works with the contracts. Okay, next. Now, oh, okay. This is an interesting one. The disbursement of the earnest money. All right. I don't have anything to show you for 2023, but basically, again, we've already talked about the process of the holder. If the buyer and seller don't agree on between themselves how to disperse the earnest money, the holder, among their many things that we can do as holder, we can interpret the contract and make a decision how to disperse the earnest money. We call it the 10-day letter because we have to send notice of our intent and have to give the party not getting the money at least 10 days to lobby an objection. And one of the things we can do is interplead it into the court too. If it's too much money or too legally complicated, we can do that. Now, one of the things as holder, we've had a lot of contracts terminate this year. As a matter of fact, I just wrote my 12th 10-day letter within 2 months this weekend. I mean, it's crazy the number of contracts that are terminating where the buyer and the seller disagree on the disbursement of the earnest money. Now, sometimes they don't always disagree. For example, the last one that I just did, the seller passed away before it closed. The estate has not been through the probate court yet. So there's nobody on the seller side that has the legal authority to sign any documents. They're not objecting to the disbursement of the earnest money to the buyer because the seller can't sell right now. But there's nobody legally that can engage the estate in business. So nobody can sign the TNR. So I had to do a 10-day letter for that situation. But back to what this changes. There are a lot of times where there's a little bit going on both sides. And there are so many times as holder of the earnest money and in making a contractual interpretation, I look at the situation in total. I talk to the agents and I talk to the buyers and the sellers. And I would really, really love to split that money. It would be like, I would love to give a little bit to the buyer and a little bit to the seller because they both had something to do with it. But I cannot do that. I am not a judge. That calls for a judgment. Only a judge can make a judgment. Any holder of earnest money is charged with being responsible for that earnest money amount in total, in whole. So I have to disperse it. Any holder writing a 10-day letter has to disperse it in total. And so GAR has just added that into the contract that says no interpretation shall be made by the holder dividing the earnest money between the buyer and the seller. Now, the buyer and the seller can choose to divide it. So you guys, that's something a lot of y'all don't necessarily consider. On a T&R, on the release portion, you guys, the buyer and the seller can negotiate and split it 50-50, 60-40, 70-30. Just put it in writing how the holder is to disperse it, and the holder disperses it upon the written agreement instructions by the buyer and the seller. But as holder, we can't choose that division ourselves. Continuing on with the purchase and sale agreement. The theme of 2024 is electronics. Again, remember, we just went through that whole brand new paragraph about devices and fixtures, talking about all these smart things. Well, under the disclaimer paragraph, GAR for 2024 has added this paragraph that says, the sentence that says, buyer and seller further acknowledge that brokers, and again, that means you guys too, have no duty to ensure that the seller has terminated the seller's and or third parties' administrative access to the devices. So again, Georgia is a caveat emptor state. What does that mean? Y'all type in the chat. What does caveat emptor mean? It's a Latin phrase. What does it mean? Type in the chat. What does caveat emptor mean? Well, I'll take a drink. Correct. Y'all didn't know you knew Latin, right? Buyer beware. Woo, it sounds so scary. What does that mean? That means that the burden is on the buyer to make sure they are satisfied with everything about the property. This is actually anything you purchase. Georgia, for any purchases, is a caveat emptor state. Real property, personal property, goods, services. The burden is on the buyer to make sure that they are 100% satisfied with the goods or services they are buying before exchanging money for those goods and services. Now, our GAR contracts allow for that before the buyer obligates him or herself to go through with the purchase. We have what now a due diligence period where the buyer can do anything and everything to satisfy themselves with the property. That means inspections. That means making sure they're going to get their loan. That means checking out zoning. That means checking out hazard insurance. That means checking out the schools. That means checking out their commute to work. That means any and everything. The burden is on the buyer to check everything out. And the due diligence period means if they decide to terminate, they have that time frame to terminate, and they'll get their earnest money back. So that's what the due diligence is. But this is everything. So before they close, or after they close, or probably before they close, the buyer and the seller are responsible for themselves for terminating these this remote access by who knows whom to the house through these situations. And buyer and sellers acknowledge that you guys as agents and you guys as brokers, we are not responsible for checking up on that. And further on in the okay, we're going to talk a little bit about assignment. So let me go to my slides. Okay. And I don't have 2023, but I want to show you something. So let me go to the form itself. We have a lot of investors in our marketplace. A lot of y'all are working with investors. Some of you aren't, or some of you have not as of yet. But basically, I don't want to elaborate on this, but I need to bring it to your attention because GAR has done for 2024 a lot of things regarding assignment. So what does assignment mean? Assignment means that very generally speaking, there is a seller that has a property. Somebody, typically an investor, I'm just going to say it's an investor will write an offer on that property and go binding with the seller. That investor has absolutely no intention of living in that house. What they are going to do is they make money by being the middle person. That investor locks up that house with a purchase and sale agreement acceptable to the seller. That investor says, now I am going to go find an actual end buyer. They're going to basically buy the contract from me. They are going to buy my position in the contract. And this buyer number one is the investor. This buyer number two is going to be the one who actually goes to closing. It's their money they give the seller, and they're the ones that are going to live in the house. Well, what do I get out of it as the investor? I get money. I contract with the seller to pay X amount of dollars. I then find buyer number two. Buyer number two pays me a different amount of money for the contract. So basically what the investor does is the investor is assigning their contract to buyer number two. You're thinking, well, if there's money to be made, if there's more money, if the investor can sell it to somebody else for a higher price than they bought it for, don't you think the seller needs to be aware of that? Because that money the seller might want to make and would sell directly to buyer number two and not the middle investor. Therefore, the GAR contracts, the Georgia Association of Realtors contracts, this is not a statewide law, this is contractually driven, are not assignable in and of themselves without the seller's written permission. So wouldn't that be fraud? No, it's not fraud at all. It's just an investment strategy. They're investing in real estate and selling the contract to somebody else. But that's why the seller has to give permission. So the seller has to give written permission. So you agents working with investors, you need to make sure that the contract that the investor buyer is writing is assignable. So, and James, this is going to make a little bit more sense with some of these forms that GAR has for this assignment. So basically what this says is any agreement to terminate this agreement must be in writing of somebody. Okay. This agreement may not be assigned, special stipulation 611. I'll show you that in a second, or listed for sale in a multiple listing service by the buyer prior to closing, except with the written approval of the seller. And the seller does not have to agree. It says which may be withheld for any reason or no reason. Any assignee, that's buyer number two, shall fulfill all the terms and conditions of this agreement, including but not limited to the obligation to pay any real estate commission owed by the assigner. So this is in the purchase and sale agreement. So let me show you what special stipulation 611 is. There's also, for you agents who are investors yourselves, there's a special stipulation. It's not new, but you might not be aware of it. So special stipulation 611 says seller consents to assignment. The seller consents to the buyer. In my example, this is the investor, assigning this agreement to another buyer who is now, for contract purposes, called the assignee, and having the assignee become the buyer thereunder. So the assignee now becomes the buyer per the contract. Just while I'm here, this is not new. This is just for informational purposes for you agents on this class who are also investors. GAR has a special stip 104 Agent's intent to resell property. All parties acknowledge that buyer agent is a real estate licensee under the laws of Georgia and is acting as principal in this transaction. Seller acknowledges that in agreeing to the sales price of the property set forth, seller has had the opportunity to seek an independent appraisal or other independent expert advice regarding the value, and seller is not relying on the advice of the buyer or another licensee in the real estate brokerage firm with which the buyer is affiliated. And 3, buyer may resell the property now or in the future at a higher price. Again, you agents who are also investors, you really need to protect yourself and include this special stipulation in your offers to owners. Okay, there's another new form, but before I get to that form, let me go back. Let me point out this one thing here. Or listed for sale in a multiple listing service. What on earth is that all about? Well, sometimes these investors, how are they going to find another buyer? Well, they would love to list it in an MLS service. The problem is, number one, license law for you agents, because a public person can't list in MLS by themselves. They need a broker to do that. License law says, number one, you cannot be misleading in any of your advertising. And number 2, you need to have the owner's written permission to market a property for sale. Well, this investor person, they're not the owner, are they? The actual original seller is still the owner. So they've just added this in there, that you do have to get the seller's written permission. Now, just while we're here, GAR has also created a brand new form for 2024 regarding this same issue. This is a new form this year, and it is called Notice to Seller of an Assignment. So that special stipulation would go in the purchase and sale agreement. In the offer, the seller says, okay, I give you buyer number 1/investor permission to find somebody else to buy it and assign the contract to the assignee or buyer number 2. Once the investor finds the assignee, finds somebody who's actually going to go to closing and move into this house, you would send the seller this notice that the investor has found somebody who's going to actually buy the property from them. So you reference the purchase and sale agreement, and here the original buyer is the name of buyer number 1 or assigner, or in my example, the investor. Then you put in the name of the seller. Then it says original buyer having the right to assign this agreement does hereby give the seller notice that the original buyer has assigned the agreement and all the buyer's rights and obligations to, and you name buyer number 2 or the assignee. And this is if there's more than one buyer on there. Collectively, all of those people are considered the new buyer, who will now step into the shoes of the original buyer and become the buyer under this agreement. The new buyer's address and contact information is as follows, and you fill in all this information, and if there's more than one, you fill it in for every buyer. That's the assignee or the person that's actually going to go to closing. By signing this notice to seller of assignment of purchase and sale agreement, original buyer and new buyer acknowledge that they have read and understood this notice to the seller, assignment of the purchase sale, and agree to its terms. New buyer consents to receiving notices. So this is actually signed by buyer number 1, the investor, and buyer number 2, who is actually going to live in the house, but it is sent to the seller. So signed by assigner and assignee, but sent to the seller. Brand new form for 2024. So I'm not going to get more. I think I might come up with a new CE class on investment, because we get a ton of questions about this, and it's not pertinent to everybody, but because it's a new form, and there are a lot more investors in our marketplace, I wanted to cover it in this class. All right. Moving along. Okay. Under this paragraph, rules for interpreting this agreement, they've added a brand new paragraph. So let me show you where this is, and then I'll discuss it a little bit. So this is we're under the purchase and sale agreement, and we're under paragraph 4 other. This is all the other miscellaneous stuff, electronic signatures, GAR forms, notice of binding agreement date, so forth and so on. They've added 2 new things to survival, and they've added a brand new paragraph under rules for interpreting this agreement. So I just wanted to show you where it is, and now let me go back here to the slides. So they changed this 2 years ago. This used to be, we know this as agents, and this used to be spelled out under the exhibits, and they added this whole paragraph. So basically, the order that takes precedence is whatever is pre-printed in the purchase and sale agreement in and of itself. Then if you have a pre-printed purchase and sale or exhibit or amendment, any document, and then you handwrite something, as long as that is initialed by both buyers and sellers, both parties, that takes control, or now that comes into play, or that now supersedes what was actually pre-printed on the form. Then if you have an exhibit that changes something in the purchase and sale, that exhibit controls over what was handwritten, which controls over what was pre-printed. Then, if you have a special stipulation controls or takes precedence over an exhibit, which controls over what was handwritten, which controls over what was pre-printed. What does this mean? This means, y'all, stop writing special stipulations for something that is already addressed in the contract. What do you mean, Dana? Here's what I mean. There's a purchase and sale agreement, buyer and seller. Let's say you represent the buyer, buyer's getting a loan. You use one of the loan contingency exhibits, use a conventional loan contingency exhibit that addresses appraisal. What happens if it appraises low? What do you do? Who can terminate? When? How do you notify the other? Who gets earnest money? All of that is spelled out in the appraisal section of the conventional loan contingency exhibit. And then what do? You write a special stipulation that says property must appraise for contract sale price. You think you're doing your buyer a favor. You are not doing your buyer a favor, because right here, we know a special stipulation shall control over an exhibit and the main body of the agreement. So you write property to appraise for sale price. Well, what happens if it doesn't? Can somebody terminate? Who gets the earnest money back? Are there time frames? Are there notices? So if it doesn't appraise for sale price, can the buyer terminate? No, not necessarily. If they terminate, do they get the earnest money back? No, not necessarily. Why do you say that, Dana? Because the special stipulation that you just wrote just says it has to appraise for sale price. It doesn't say what happens if it doesn't. All of that was in the exhibit that you just now totally negated by writing a special stipulation that addresses the same issue. You're not an attorney. You didn't write all that stuff in. So stop writing special stipulations that address an issue already addressed in the purchase and sale, as long as you're not countering it. What would be a special stipulation you might want to use? Well, pre-printed in the GAR form, it says under certain circumstances that the parties have the right to unilaterally extend the closing for 8 days. Let's say the parties don't want that. You could write a special stipulation that says all parties agree there is no right to unilaterally extend the contract. That would be something that is addressing something already in there that the parties agree don't want in there. So that we already know that from pre-license school. That's just spelled out in case you forgot, and for our public people. Now, in last year, what they added is, notwithstanding the above, any amendatory clause in an FHA or VA exhibit shall control over inconsistent or conflicting provisions contained in a special stipulation, another exhibit, or the agreement. What is all that about? Well, in the really, really fast market that we experienced a couple of years ago, we were having buyers doing all sorts of things to make themselves competitive and try and convince the seller to choose their contract over a competing buyer's contract. And one of the ways that buyers were trying to entice a seller to take their contract, they were getting an FHA or a VA insured loan. And the appraisal protection or the appraisal clause for an FHA or a VA loan is called the amendatory clause. It doesn't say appraisal, but in essence, the amendatory clause, again, FHA and VA are government entities. You cannot, government entities have federal regulations regarding the money they insure through an FHA or VA insured loan. You cannot write a special stipulation that overrides that. So here's what was happening. We would have a buyer getting an FHA insured loan, really wanted that property. So they would add a special stipulation that says, should property not appraise, we would call it the appraisal gap stipulation. Should the property not appraise for sale price, buyer agrees to bring cash for the difference and go to closing. Well, if they were getting an FHA or VA insured loan, I don't care what special stipulation they wrote, a buyer, if the property did not appraise, the buyer could terminate through day of closing and would get their earnest money back despite any special stipulation they wrote, because the government federal laws supersede any special stipulation written and contracted for between two private parties. So in 2023, they put that in there, that notwithstanding anything above, the amendatory clause takes precedence even over a special stipulation. For 2024, they have added another paragraph. Yes, a lot of unnecessary special steps. In 2024, they have added paragraph 5 under this section, again, having to do with the amendatory clause, which again is the appraisal protection for a buyer getting an FHA insured loan or a VA insured loan. And it states for next year, notwithstanding the above, the amendatory clause in the FHA or VA exhibit shall control over inconsistent or conflicting provisions contained elsewhere in this agreement. Buyer and seller acknowledge and agree that the further agreement pertaining to the amendatory clause section in the FHA or VA exhibits, which we'll get to in just a minute, does not conflict and is not inconsistent with the amendatory clause. Again, it is just, this is just more that, look, you guys, federal regulation and rules and laws supersede any agreement. Yes, you guys, this verbiage is in the GAR, Georgia Association of Realtors contracts. A lot of builders use their own Atlanta Builder Association contracts, and this verbiage is not necessarily in there. However, an FHA or VA insured loan, the buyer's earnest money is protected through day of closing, even in new construction. This is not a contractually driven thing. This is a legal law driven thing. It is protected should the property not appraise. Now, in new construction, very rarely does it not appraise for contract sale price. But you buyer's agents, y'all, the buyer can't just not show up for closing. You have to send a notice of termination prior to closing. And I'll get to that when we get to the exhibits that they've changed. All right, now in the survival, the two things that they have added to what survives the contract, meaning what gives legal precedence, what the buyer and the seller are still obligated to, even after you close, are only these things itemized in the survival. And they've added, in the survival section, they've added two new things. Number 8, the section on devices and fixtures, which is that brand new paragraph that they've added. And number 9, seller's liability for not timely removing items from the property that the seller agreed to remove. So they've just added those 2 more items to the survival. All right. two brand new paragraphs in the purchase and sale. Let me show you where they are. Same thing, this whole brand new paragraph F on closing, and this whole brand new paragraph 7. So I just wanted to show you where they are in the contract. The rest of this GH, those are the same. It's a little bit closer up in my slide, so let me show you from the actual slide. So we know, will you tell me, type in the chat, when is a contract actually closed? When is it technically considered closed? When's a transaction closed? Type in the contract. When do you think it's actually closed? Funded. Yep, you guys are right on target. Money, follow the money, right? Follow the money. Until the money is there and has changed hands, we are not technically closed. So it gets very confusing for our buyers and sellers when they're at the closing attorney's office late in the afternoon and they have a closing. Everybody signs everything, and you sit around and you chit chat. And sometimes it gets comfortable, sometimes it gets boring, sometimes it's fun, but you chit chat for the closing attorney, waiting to hear from the lender that it's approved and it has funded. Well, if we have a closing late in the day or there's some issue or whatever, sometimes everybody will sign documents, but it won't actually technically be closed until the following day. Well, my goodness, what do you do? What do you do about possession and keys? And is it closed or are we not closed? It gets confusing for professionals as well as for the public. So GAR has added this paragraph to define what a closing is. And it says, the closing shall be the event in which the parties consummate the transaction set forth this agreement by, number 1, seller tendering the deed referenced herein to the property. 2, buyer paying the required consideration hereunder. 3, both parties properly signing all documents and paperwork as required by the closing attorney. And 4, both parties fulfilling other agreements set forth herein that must be fulfilled by closing unless they have been waived or amended. The closing shall be deemed consummated when the closing attorney confirms to the parties that closing attorney is in receipt of all required paperwork, funds, and approvals necessary to complete the transaction, and directs for the funds to be dispersed and documents to be recorded. All parties acknowledge that the deed will not normally be recorded in the land records on the day of closing, and the payment for the sales proceeds may not always be made to the seller on the day of closing, even though the closing has been consummated, due to certain circumstances, such as, for example, seller not being at closing in person, closing occurring after the cutoff for wiring funds that day, or the terms of an escrow agreement signed by the seller have not been fulfilled, resulting in which a portion of the seller's funds are being held back. Yep, no keys until funding. What do y'all do? I suggest you bring a blank amendment with you to the closing table in case it is not funded, but buyer and seller agree for possession to go ahead and take place. Probably want to bring a blank amendment and perhaps a temporary occupancy agreement. Just as a point of practice, because this happens a lot, not due to anybody's fault, just because of those issues. And then this next new paragraph, we have had, I sincerely hope none of y'all have been a party to this or know anybody within your brokers that have been a party to this, but there is rampant seller fraud going on. There are bad guys impersonating sellers and closing properties and getting money. Now in Georgia, we've had, it's rampant. And in Georgia, we've had a lot that have gotten up to the closing table and haven't closed. Some have closed. It's just a nightmare and it's very scary. Typically, it's land or it's vacant property. Typically, we see a lot of land and the listing agent never meets in person or via Zoom with the seller. So at point of practice, you guys, you definitely want to at least just be careful if it's land, number one, and number two, if you are not meeting with the seller in person. But GAR has this brand new paragraph, heightened identification procedures to help prevent fraud, and covenant not to sue. That protects us. There has been a significant increase in criminals attempting to sell properties they do not own by posing as the owners of those properties. To help prevent such crimes, seller shall immediately, upon request of either the seller's broker and or the closing attorney, 1, provide the requesting party with information confirming the seller's identity, including a government-issued photo identification. 2, meet in person or through audio-visual conferencing to confirm the seller's identity. And 3, if the seller is a legal entity, i.e. like an LLC or corporation or something, or a trust, provide the requesting party with the organizational and operating documents of such an entity and current photo identification, and either meet in person or in an audio-visual meeting with the executor, manager, trustee, general partner, officer, administrator, or other person in a comparable role of the legal entity to confirm their identity. Seller further agrees to cooperate with the closing attorney's heightened identification procedures, which shall at least meet the standards, if any, supplied by a title insurance company for whom the closing attorney is an agent. Seller acknowledges that the transaction may not be able to close unless such procedures are followed. In the event seller breaches its obligations hereunder, seller shall be in default of this agreement. Buyer acknowledges that identity theft may occur regardless of the measures undertaken by the parties, their respective brokers, and the attorneys involved in the transaction to confirm the seller's identity. For and in consideration of $10 and other good valuable consideration, the receipt and sufficiency of which is hereby acknowledged, buyer covenants not to sue any broker and or closing attorney involved in this real estate transaction for damages arising out of or related to a fraudulent seller. Very crazy. And then under exhibits, they have added 2 additional lines. So it used to say other. I'll show you really quickly. It used to have 1 line for other. They just added 2 more others. And that is it for the purchase and sale. Same changes they made to the other purchase and sales: lot and land, and new construction. All right, it's 11:12. Let's take a break. We will come back and finish up the loan contingency exhibits and all the rest. I know I spent a lot on that, but you guys spend more time on the purchase and sale than anything, and there were some pretty important changes. So let's do this. Let's take a break and come back. All right, everybody, welcome back, and we are going to continue on. So let me go back and share my screen. We're going to start with the financing, go through community association disclosure, seller's property, so forth and so on, and we will knock it out. So, all right. Continuing on. Here we go. Continuing on with the financing exhibits. So in all of the financing exhibits, let me pull up the chat so I can see any questions. All right. In all of the financing contingency exhibits, conventional, FHA, VA, they have changed this. So in column A, paragraph A, where it describes the type of mortgage that a buyer is getting, it has a loan amount, which is a % of the sale price, the term, the interest rate, if it's fixed, adjustable interest only. And in 2023, they had source of the loan. Are they getting an institutional mortgage? Is it seller financing or other? We used to have a lot of agents that were again, working with investors getting a hard money loan, use this conventional financing contingency exhibit and just mark other to indicate they were getting a hard money loan from somebody other than an institutional mortgage. For 2024, GAR has removed this column, source of loan terms. So you will only have loan amount, term, interest rate, and rate type. Now, in the appraisal contingency, that is the other thing that they have changed in the conventional loan exhibit. So in 2023, it said nothing herein. Okay, let me do this. Let me show you what it looks like, and then I'll tell you what they added on. So let's, okay, here we go. All right, so here is we did that. All right, conventional loan contingency exhibit. Make it a little bit bigger for you. Again, they took out the column, so it's just the rate. Then we scroll all the way down to the appraisal paragraph, paragraph 13. And basically, they've added, for 2024, they've added on a paragraph. But what it says, basically, okay, this gets really confusing. They changed this last year too. Under the financing contingency period, the time frame is in here, paragraph 3. This was new in January of last year. So the buyer has so many days from binding agreement date to convince a lender to lend them the money. If not, they have to send notice of termination before this time frame, and then they have 7 days thereafter to prove it with a loan denial letter. Now, this next fill in the blank for time frame has to do with the appraisal, but it gets really, really confused by a lot of agents because this form has undergone some changes throughout the years. This appraisal contingency time frame is how we refer to it, but it's the length of time for a buyer to request a reduction in the sale price. The time period for the buyer to request a reduction in the sale price, if it appraises for less than purchase price, is so many days from binding agreement date. So let's say we have 21 days from binding agreement date. Let's say the appraisal comes in low and we are 20 days from the binding agreement date. That does not mean that your buyer sends a termination. If they send a termination notice based on a low appraisal within this time frame, they have just defaulted on the contract. This time frame for a low appraisal is completely different from the time frame for the financing contingency. They do have to terminate before this, but here they don't terminate or they will default. They have to give the seller the opportunity to sell it to them for the appraised price. A buyer on a conventional loan may not terminate immediately upon learning of a low appraisal. They have so many days, in my example, 21 days from binding agreement date, if the appraisal comes in low, to send the seller an amendment to the sale price and a copy of the appraisal, asking them to sell it to them for the appraised price. And then this paragraph 13 explains all those timeframes. Then the seller has so many days to accept or reject. And then the buyer, if the seller rejects it, the buyer can then terminate after this specified time frame. If the seller agrees to sell the house to the buyer for the appraised value, the buyer is obligated to go through with the purchase. Now, what this says at the bottom of this paragraph explaining the appraisal contingency, it says, nothing herein shall require the buyer to seek a reduction in the sale price, meaning the buyer can still pay full price for the house. If the buyer does not seek a reduction in the sale price, the buyer is obligated to purchase the property for the price agreed to by the parties in the agreement. In other words, if it's a low appraisal and the buyer doesn't give the seller the option to reduce the sale price, the buyer is obliged to close at the higher price. It is now spelled out. A buyer on a low appraisal getting a conventional loan does not have immediate termination rights, period, end of story. They just spelled out that obligation on the conventional loan. Now, on to the FHA and VA. So they've added a new paragraph 13. So this is on FHA and the same as on the VA. Let me show you on the documents themselves. I think it's easier to see. This is the FHA loan. Again, the columns are the same in all of the exhibits where they took out the source. All of this is the same. All of this is the same. As we've already mentioned when we were talking about interpreting the contract, if a buyer getting an FHA or VA insured loan, the appraisal comes in less than sale price. Now, on the FHA, you have to fill in a dollar amount here. On an FHA insured loan, buyer and seller get to negotiate the amount for the appraisal. Typically, that does become the sale price, but if you're countering with counteroffers, make sure to address that. But this is a dollar amount negotiated by the buyer and the seller. This amendatory clause we've already addressed, you guys already know, it says if HUD FHA says the value of the property is less than this dollar amount, a buyer may terminate the contract prior to closing and will get their earnest money back. Again, can't walk away, but you have to send the termination notice before closing. Their earnest money is protected. Nothing the seller can do about that. Brand new for 2024, GAR has added in this brand new paragraph, further agreement pertaining to the amendatory clause. What this says is, notwithstanding the above, if the written statement by the Federal Housing Commissioner or direct endorsement lender sets forth an appraised value that is less than the minimum appraised value, which is this dollar amount spelled out here, buyer shall immediately provide seller with a written copy of the appraised value. Seller may, but not required to, within 5 days from the date buyer delivers notice to the seller of the appraised value, reduce the purchase price to the appraised value upon notice to the buyer. In such event, the parties shall immediately prepare and sign an amendment reflecting the new sale price, deliver it to the other party, and they shall then close the transaction at this amended sale price. All other provisions remain unchanged. Amendatory clause shall remain in full force and effect even if the financing contingency has expired. So that's it for FHA. And then for VA, this is the VA loan. Same thing, remove the column. Same thing about the amendatory clause, this new paragraph, but the only difference is there's not a dollar amount negotiated by the buyer and the seller. It's just reasonable value as assessed by the Veterans Administration's appraisal, basically. And that's it for the VA loan. All right. Loan assumption exhibit. Because interest rates now are higher than they have been within the past few years, we are seeing a lot of buyers negotiate. Do I have this here? Oh man. Well, darn it. I'm going to have to get a copy of that. I thought I had it. Oh, here it is. I do have it. Okay. We have seen a lot of buyers negotiate to assume the seller's current loan. This, okay, I guess I've got both. This is the 2023 exhibit. And darn it. You know what? I downloaded the wrong exhibit. All right, hang on. Let me grab the new exhibit. While I do this, let me stop share for a second. Let me grab this. I will tell you guys, there are a lot of buyers attempting to assume a seller's current loan. I mean, why wouldn't you? Why wouldn't you want to get a loan at 3% versus a loan at 6 or 7%? But so first of all, FHA and VA loans cannot be assumed. It is just a conventional loan. Additionally, I will let you know that it is my understanding it's not quite as easy to just assume a loan as you would think. Why? Well, that makes sense. A lender is going to want the higher interest and is not going to want to just take over somebody's low interest rate when they can make more money on the interest. So it is a bit tricky, but they are doable. And if you are a listing agent and you have you have access, if the seller's loan is assumable, then 416, here we go, then it is a great benefit if you can if you can market a listing for sale with an assumable loan. Not always easy to do. I suggest you totally get with lenders to go through that process if you're working with buyers and sellers and find out what's involved, so forth and so on. And I am getting ready to show this to you quickly. What they have done for 2024 is GAR has, here we go. GAR has, we haven't used this exhibit in a long time. So GAR has basically brought this, here we go, brought this exhibit up to speed. Okay, what has happened? There we go. Brought this exhibit up to speed to make it look similar to a lot of other exhibits that we are used to. So there we go. This is the 2024 loan assumption exhibit, and it looks very similar to the other financing contingency exhibits that you're used to seeing. It talks about what a loan assumption is. It talks about, are you determining the purchase price based on cash to control or the purchase price to control, the existing loan information, current loan information, seller warranties. If it's a VA loan, if your buyer is a veteran, they need to make sure that they do have their VA entitlement for the assumption, financing contingency period, the appraisal issue, loan denial letter. All of this stuff is the same that has been in all the other financing contingency exhibits for several years. Again, GAR just has not addressed this loan assumption exhibit because it has not been used in many, many, many years. So they've added this verbiage in there. That's verbiage you're familiar with from the other exhibits. So just wanted to show you guys that. Again, I highly suggest you get with a lender to go through this and really learn it inside and out. All right. Moving along to the sale or lease contingency. So they made a couple of changes here, nothing drastic, but one of the things is the contingency time frame. And I love this change as a broker because what was happening is, all right, let me go back here and find the actual form. Here we go. So basically, this got really crazy with some clients because this is a buyer buying a new home. They have a current home, they have to sell it. Well, you fill in this contingency time frame. This agreement is contingent upon the buyer basically selling their new home before, and there was a fill in the date. And a lot of you guys were filling in the date of the closing for the new house. In 2024, so that's what it looked. It said this in 2023, it said this agreement is contingent upon the following contingency before fill in the date. In 2024, it now says the agreement is contingent upon the occurrence of the following, again, either getting a lease or selling the house. You check the box, the closing date of the agreement, including any extension, or a specific date. Why is this a good thing? Because of paragraph 4. Paragraph 4 says, in the event the contingency period ends without the buyer having sold their current home or getting a lease, then the contract for the new home, then this agreement shall terminate at that time. So what was happening is you would fill in closing date, and then the closing date of the new home got extended by amendment or by 8-day unilateral extension, and the parties forgot to go back and address this sale or lease contingency time frame. So what happened? Contract terminated automatically because we passed this date and the house didn't close, and the buyer didn't necessarily want to terminate, and the seller got a new buyer, or the buyer wanted to terminate, found another house, and the seller was just stuck because it automatically terminated. So now GAR's added in that the close it's in concert with the closing date of the contract for the new house, including any extension, so that you don't have to worry about any mistakes. Then under the kickout clause, again, sale or lease contingency, they added a new sub paragraph that basically says, if the seller gets another contract they want to accept, then they go to the buyer and either kick out all contingencies or certain contingencies that had been in there. What they added is the subparagraph C. All unexpired contingencies shall remain part of this agreement. So that's all the changes they made for the yes, VA loans are assumable. VA and I'm sorry, VA loans. Okay, duh, because it talks about the entitlement. So thank you, Valika, for correcting me on that. I apologize. Sorry. Thank you so much. All right. Let's see what else we've got. Sale or lease, we added that. All right. Seller's property disclosure statement. So in the seller's property disclosure statement, they have added a couple of issues. One is how it is to be used by the buyer and how to be filled out by the seller. So let me show you that form. Our favorite. This gets changed all the time. Make this a little bit bigger for you. There we go. So, instructions for the seller completing this statement. They basically just summarize that the seller is to answer all the questions fully, accurately, and to the actual knowledge and belief. And they've just now used the word knowledge as one word to assume all of that information. Now, the buyer. All right. Caveat emptor, or buyer beware, is the law in Georgia. This has all been in there. What they have added for 2024, if the seller has not occupied the property or has not recently occupied the property, seller's knowledge may be limited. So seller's knowledge may be limited, might be there, but they've added that in there. They also added this entire last section that says, in other words, remember a few years ago, there used to be a maybe section, or I don't know. It had yes, no, I don't know. They took out the I don't know, and that caused major uproar among a lot of agents. What GAR is doing for 2024 is, again, this is under the section how it should be used by buyer. In other words, if a seller answers no to a question, it means the seller has no knowledge whether such condition exists on the property. As such, the seller's answer should not be taken as a warranty or guarantee of the accuracy of such answers, nor a substitute for the buyer doing its own due diligence. What does that mean in English? That means if a seller says no, it hasn't flooded, it just means to their knowledge. It doesn't mean that it necessarily has not ever flooded. It's not a factual blanket statement. It's not a warranty or guarantee of the accuracy. It's just saying, it's basically saying no or I don't know. So it's sort of like putting the I don't know column back in there as far as how a buyer should take this. So you buyer's agents, you need to make sure your buyers understand this is a guide, but not an end all be all nor substitute for any and all inspections. So that's really helpful for sellers, because we had a lot of sellers that would refuse to fill this out because they didn't want anything they didn't want this in writing to stand as a warranty or guarantee of their knowledge. It could just be they don't know. All right. Additionally, under the section systems and components, again, going along with the 2024 theme for our contracts about technology, they've added a sub-paragraph that says, are there any remotely accessed thermostats, lighting systems, security cameras, video doorbells, locks, appliances, etc., servicing the property? This is going to be an indication to the buyer to make sure that, again, those access, administrative access, so forth and so on, gets changed. Under flooding, draining, moisture, and springs, they've added a little bit of clarification verbiage. Under A, it has always said, is there now or has there been any water intrusion into the basement crawl space? And they've added or other interior parts of any dwelling or garage or damage therefrom from the exterior. And under repairs regarding water intrusion, they also added those same terms, other interior parts of any dwelling or garage from the exterior. Under soil and boundaries, they've added paragraph C is brand new, and they've added a little bit to paragraph D. So C says, are there any shared improvements which benefit or burden the property, including but not limited to a shared dock, septic system, well, driveway, alleyway, or private road? And under D, it talked about the seller's recollection or knowledge of any encroachments, unrecorded easements. They've added, for 2024, GAR has added unrecorded agreements regarding shared improvements or boundary line disputes. So sometimes there's agreements between neighbors that never got recorded anywhere. And I believe, under the fixtures checklist. So what GAR is doing for 2024, this used to all be one big old huge long paragraph. So like the Georgia Association of Realtors Forms Committee likes to do for our public, is they try to make these contracts a little bit easier to read, a little bit easier to understand, and a little clearer. So all of that verbiage really has not been changed. They've just separated it out into 3 distinct paragraphs to put it into bite-sized chunks, rather than all one big gobbledygook paragraph that our public may not have read. So they've separated out directions on how to fill out the fixtures checklist. Regardless if it's a fixture or not, sellers shall have the right to remove the items. And then talks about what happens with the items not remaining with the property. And then this talks about items remaining with the property. So the verbiage is the same. They've just separated it out. Range, it used to say stove, and they changed it to range. And I believe that is it for the seller's property disclosure statement. All right, this Okay. Now our favorite, this poor exhibit, this gets changed all the time, all the time, all the time. This is the Community Association Disclosure Exhibit. And again, let me show you guys how it looks in the form. It's easier to see. Not a big change, but a very important change. Okay, here we go. So everybody's favorite community association disclosure. And basically, we know in general, if a property has an HOA or a management company, there are lots of fees involved. There are fees that pertain specifically to the seller, like the letter of good standing, so forth and so on, release letter. There are fees that are specific to a new buyer, like an initiation fee, a transfer fee. There are fees specific to the property in and of itself, the actual annual association fee, any special assessments, any utilities, any add-on fees like for different parts of the community, like the swimming pool or so forth and so on. So there's a lot of different fees. There are some associations where we've already talked about throughout the class about caveat emptor, and the burden is on the buyer. There are a lot of HOAs, however, where the HOA or the management company will not share the financial information or fees with anyone except for the owner on title to the property. So because of this, this form basically says, okay, seller, you need to go to your HOA and management company. You need to find out these fees and you need to disclose them to the buyer because the buyer cannot find them out. So it's not as a penalty, but because you're the only one that can get this information, if you don't find them out, or if you put down something that's less than what it is at closing, you need to pay the difference between what it is and what you disclosed. That has been in there. What had not been in here is it just said assessments, and they added the word annual. And basically, so this is, okay, the HOA is X amount of dollars per year. And then how is it paid? Is it paid monthly, quarterly, semi-annually? So they've added per calendar or fiscal year. They added fiscal and they added in installments. But I'm going to come back to this in a minute. The other thing they did is paragraph 6. It used to just say utility expenses, but a lot of agents have found out that there's other fees that are just other. They cover something that we can't necessarily think of. So they changed this to other fees and made it just to fill in the blank. A fee for blank is currently X amount of dollars per year and paid in installments. This is something other than transfer, initiation, or admin fees. And then they put the utility expenses in a separate paragraph. Then under the further explanations, this is the important thing that they have done. Prior to 2024, under the special assessments and all these other fees, transfer, it was under here, transfer, initiation, admin fees. This hasn't changed. It basically says, sellers shall pay any amount in excess of the sum disclosed, even if it was later disclosed or there's an increase in transfer, initiation, and admin fees. In the event the seller fills in the above blank with NA or anything other than a dollar amount, or it's left blank, it shall be the same as the seller filling in 0. So again, seller, you have to pay what you don't disclose. This had only been true for transfer, initiation, and admin fees, but not for the actual annual HOA fee. So what happened is we actually had this experience last month. We had a seller that filled in the annual HOA fee at $1 amount. And when they got to closing and the closing attorney got the information, it was actually a higher amount. And the buyer said, well, seller, you have to pay that non-disclosed portion because you didn't disclose it. And the seller said, no, I don't. I only have to pay the non-disclosed portion for transfer initiation and admin fees. Nowhere in this exhibit did it say that if the seller incorrectly disclosed the actual annual HOA fee, they had to pay the difference. So that was an oversight by the GAR Forms Committee that is being corrected in 2024. And now it does say any fee in excess of the sum disclosed in Section A3, which is the annual HOA, the seller has to pay the remainder of the year, whatever they didn't disclose. And then the only other additions is special assessments under consideration. They just added all parties agree neither seller nor broker shall have any obligation to disclose any possible special assessments if it's not yet under consideration. In other words, if there's just chit chat in the HOA, but it's not actually been discussed in the minutes of the HOA meetings, it doesn't have to be disclosed. And the seller does pay for undisclosed special assessments that have been approved or disclosed above. So those are the only changes to that. All right. All right, temporary occupancy agreements. This is the temporary occupancy agreement for the seller after closing. If the seller is going to stay for a few days after closing. Same thing that we've already addressed in the purchase and sale agreement about the fobs and access cards. They just put that same verbiage in the temporary occupancy, that at time of closing, seller shall provide buyer with one set of keys, door openers, fobs, access cards, codes, and equipment needed to access the property and community amenities. So I guess what was happening is sellers were giving a key and door opener to the house, but the buyer couldn't access the swimming pool or whatever. Anyway, so they've just brought that verbiage into the temporary occupancy agreement for the seller to stay after closing. And then this temporary occupancy agreement for a buyer prior to closing, very, 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 very tricky. I highly encourage you to not do this, but I understand there are certain situations where the buyer might have to occupy the property prior to closing, and the seller agrees. So you would use this temporary occupancy agreement for the buyer prior to closing. And it just says the seller has confirmed if the property is located in a limited access community that the buyer shall be given access. Again, that's like a gated community. They've added just the same theme that we've been talking about. And a brand new paragraph in this exhibit, paragraph 16. At the time of buyer's occupancy, to the extent allowed by the community association, seller shall provide buyer with one set of keys, door openers, fobs, access cards, codes, other similar equipment. Seller shall also cooperate with the community association to provide buyer with access to the community and community amenities. At time of closing, to the extent allowed by a community, seller shall turn over all remaining keys, door openers, fobs, access cards, similar equipment to access the property, community amenities in seller's possession to buyer. In the event the sale is not consummated for any reason, buyer will return all of said items. So they've just, again, brought in that same theme with everything. All right, agreement to reinstate contract. This is a great change that they've made here. So basically, once a contract has been terminated, it is dead. There is no CPR for a dead contract. Really, if the buyer and the seller wanted to go back under contract, technically what you needed is you needed a brand new contract. The problem is, the lenders had a cow. They're like, I can't write a brand new contract for this buyer within 30 days or 60 days or whatever. I have to use the existing contract. And we're like, it's dead. You can't amend a dead contract. So we had to get with attorneys to write up these agreements, so forth and so on. So last year, it was either last year or 2 years ago, GAR went ahead and did that legal work and came up with an agreement. Again, it's an agreement. It's not an amendment because the contract is dead. So this is an agreement that buyer and the seller would use to bring back to life or go back under contract, a contract that had been terminated. And it basically says that we go back to everything in the contract as it had been before the termination. The problem is, what if we had a TNR, earnest money got dispersed, and then the buyer and the seller decided to reinstate the contract? Well, what do you do about the earnest money? It's already been given back to the buyer or the seller or whatever. So for 2024, GAR has added in a paragraph here that says, yeah, oops, I didn't mean it. That says, if the earnest money has been dispersed by the holder, this agreement shall be contingent upon the buyer paying the holder earnest money of X amount of dollars within so many days from the reinstatement date. So typically, the only other items you really have to address here would be the closing date. If this gets terminated and reinstated really close to the original closing date, you might have to address the closing date here. But this earnest money was an issue, so GAR has added in this paragraph about earnest money. Now, a lot of times, sometimes you guys, let's say sometimes a buyer will terminate because you're under contract, the appraisal comes in low, and the agents are going back to the appraiser trying to get a higher appraisal value, and the appraiser's taken their time, it's not coming in, and the buyer needs to go ahead and terminate to protect their earnest money. So they terminate, earnest money gets dispersed to the buyer because they terminated under the appraisal contingency within all those time frames. And then a week or so later, 10 days later, let's say, you do get the appraiser to change the value to a higher amount, and both parties decide to go back under contract. That's a very we saw a reinstatement a lot for that reason. Or a buyer couldn't get a loan through one lender, they terminated under their financing contingency, they ended up finding another lender who could finance them, or they lost their job and got another job, so forth and so on. So there's a lot of reasons to use this, but this is a nice addition with the earnest money. Okay, this form is not, let me go back to the slide. This is not a new form. I just want to remind you guys, this is here. Co-op commission agreement to be used prior to showing. If you are working with a buyer and you are showing a property that is not in an MLS service of which you are a member, do not work for free. You need to confirm either your buyer is going to pay you by virtue of the commission they agreed to pay you on your buyer brokerage agreement, or you need to negotiate with the seller's broker any commission that they are going to pay your broker. You get this negotiated up front. Again, if a property is not in an MLS, including new construction, use this prior to showing. It looks like instructions to closing attorney, but it is commission paid by the seller and how it is to the buyer's broker and how it is divided out. Not a new form, just wanted to remind you that it is there. Okay, moving on. We are going to make it, everybody. Moving on to the brokerage agreements. Under the seller brokerage agreement, I'm just specifically in the slides going over the exclusive, but they made the same changes in the 104 F104, the non-exclusive. Oh, also, I meant to tell you this too. In all of the dates, they removed the 20-dash, and it's just a date line. So it says commencement date of this agreement blank. It's not blank 20 blank blank. So they've done that in the dates. And commission. So there are a lot of lawsuits going on about commission. Sellers are, there's a big national lawsuit. There was one that was just decided in Missouri that is now in the appellate courts. GAR is under the impression that and a lot of other people online that lawsuit, that judgment by the lower court is going to get totally thrown out in the appellate court, but we shall wait and see. There are a lot of what we call copycat lawsuits throughout the entire country. There's one filed in Georgia, one in Florida, one in Pennsylvania. There are a lot of these so-called quote unquote copycat lawsuits where sellers are suing brokers and NAR and the MLS services for commissions. And I'm not going to get into that. You can Google all that stuff online. And again, this is, we are currently in December of 2023, and a lot of this is changing very, very rapidly. But GAR and the MLSs, I will say the two that I am specifically familiar with, FMLS and Georgia MLS and GAR, throughout the past several years, have verbiage in them, and the MLSs in their membership agreements that is designed to protect Georgia brokers and Georgia affiliated licensees. There is a lot of pre-printed verbiage in our contracts that protects you guys. That is something, it's like an insurance policy. That is money. When you pay your monthly premiums for insurance, you hope that is a huge waste of money and you never ever need to use that insurance policy. There is a lot of pre-printed verbiage in the Georgia Association of Realtors contracts, thanks to legal counsel overseeing GAR. For years and years and years, it has been Seth Weissman, and more recently, it's Seth Weissman and Christina Chow and the GAR Forms Committee throughout the years, and the Georgia Association of Realtors themselves. There is so much verbiage pre-printed in our contracts that protects brokers and agents from some of these issues that are being discussed in these lawsuits right now. Additionally, GAR continues to change the commission paragraphs in the seller brokerage agreements and in the buyer brokerage agreements because of everything that has been changing. This has been changed for years. Definitely the way the commissions read, especially in the buyer brokerage agreement, has been changed years ago. They just keep tweaking it and tweaking it. Additionally, in Georgia, just so you know, because we're having this brief discussion about this, our real estate industry in the state of Georgia, our practice is state regulated by the Georgia Real Estate Commission. There are other states in the union where the practice of real estate is not regulated on a statewide level by a state government agency. And in Georgia, unlike a lot of other states, I believe there are only, I don't remember exactly, but I believe there are only 16 states in the country, I could be incorrect on that have buyer brokerage laws. So we have buyer brokerage laws in Georgia that also protect us, our brokers, our agents, and our buyers. So there's a lot of things about Georgia. Be blessed that you are practicing real estate in Georgia, and that the state on all sorts of levels has done a lot of things to protect you and your practice, as well as our buying and selling public with respect to the exchange of real property. So, all of that being said, let's talk about the changes that 2024 GAR has made in the seller brokerage agreement. So one is under the commission section. Here in my slide, this is what it shows in 2023. Again, we're in the seller brokerage agreement. It has commission. Seller agrees to pay the broker the following commission at the closing of any contract to sell of the property as follows: either a % of the sales price, a flat fee, or something else. Then it says, that's paragraph 4A. 4B says the broker agrees to pay a cooperating broker, if any, whatever. So we would see a larger number here, and then a percentage or a smaller number here. So we would see a % here, and then typically half of that % here. A big flat fee here, half of that flat fee here. So that's how that got divided out. And then it had commission adjustment to cooperating broker. There may be certain circumstances where the seller's broker shall not pay the cooperating broker commission as referenced above. These circumstances and the commission that shall be paid in such circumstances are as follows. And a lot of times we would see things such as if the buyer's broker is not present at the first time of showing, then the co-op broker commission shall be a different percent. That's just an example. That's how it looked in 2023. And the seller is fully aware of what they are paying and what is getting shared with the buyer's broker. 2024, the verbiage is changed just a little bit. And it says, commission to be paid to the seller's broker. Seller agrees to pay the broker the following commission at the closing of a contract. That's the same, blank percent of the sale price, flat fee, or other. Then paragraph B. So let me show you again. This paragraph B says broker agrees to pay, cooperating broker. This says seller directs the seller's broker to pay or not to pay a cooperating broker a portion of the seller's commission above. Nothing herein shall obligate the seller to direct the broker to pay any portion of its commission to a cooperating broker. In such event, the buyer shall be responsible for paying the cooperating broker's commission. If the seller's broker is paying the cooperating broker a portion of its commission, it shall be in the amount set forth below. Again, this would be a bigger percent, a lower percent, a bigger amount, a lower percent. And then here are the exceptions. All right. Then in the corresponding paragraph, let me show you the actual form. I just wanted to show you that juxtaposition with the 2023 verbiage. So that's here under the commission. Now in the corresponding paragraph to commission, it says, if sharing, so there's the obligation of the seller to pay a commission, sharing of the broker's commission with the cooperating broker. If the seller has directed the broker to share its commission with the cooperating broker as specified above, it shall be shared with the broker, if any, who procures a buyer. If this agreement specifies that no commission is being paid by the seller's broker to the cooperating broker, then no such commission obligation shall exist, and the cooperating broker's commission shall be paid by the buyer. Seller's broker shall have no obligation to pay a cooperating broker who's not a participant in any MLS service in which the property is listed a commission unless a cooperating broker has negotiated and executed 258, which is that form I just showed y'all. Commission agreement to be used prior to showing. This is 258. All right, and then under the disclosure statement, they just reference the form numbers. We're going to come back to commission. Does MLS cooperating broker percent override this paragraph? No, the seller has to, because the seller doesn't sign an MLS agreement, and there can be typos in the MLS listing. The listing agreement overrides any advertisement in an MLS service of cooperating commission. Good question, Linda. Thank you. All right. Under the FERPTA affidavit, this has been in the purchase and sale agreement, and it has been in the buyer brokerage agreement. They just neglected to put it in the listing brokerage agreement, so they've just added it. And basically, if a person is considered a quote unquote foreign person as defined by the IRS, there are certain taxes that the closing attorney has to withhold. Again, it's been in the purchase and sale and the buyer brokerage. They've just now added it to the seller brokerage agreement, but it's not anything new. And that's it for the seller brokerage agreement. Let me talk about the buyer brokerage, and then we'll get to the Then I'm going to get to the specials. We're going to have a little bit more discussion on commission, and then I'll show you the other forms. I know we're running tight, so give me 1 second. Commission on assignment. I missed that, but basically it just says that if the buyer assigns the commission, the buyer, I'm on the buyer brokerage. I don't know why that's there. The buyer has to pay commission. Why? Okay, I've already talked about that. Okay, buyer brokerage. In 2023, under the buyer brokerage, it says buyer's commission obligation. It used to say buyer agrees to pay broker commission set forth below at the closing of the contract entered into during the term of this agreement, minus any commission paid to the broker by either seller's broker or seller. Buyer acknowledges that the commission, if any, being offered by the seller's broker is usually set forth in the multiple listing service in which the property may be listed. That's how it read in 2023. In 2024, they put it all in caps. They removed any reference to co-op commission being identified in an MLS service. And the issue is we had a lot of quote unquote off-market properties being sold. So in 2024, this is how it reads in the buyer brokerage agreement. Commission. Buyer agrees to pay the broker the commission set forth below at the closing of a contract to purchase entered into during the term of this agreement, minus any commission paid to brokers by either the seller's broker or the seller. Buyer acknowledges that neither seller nor seller's brokers are obligated to pay any commission. And then here's the commission on assignment. If the buyer has the right to assign the purchase and sale, buyer shall cause the assignee to be responsible for paying the broker's commission. And again, under the corresponding paragraph under commission, buyer shall be obligated to pay the broker's commission reference here in accordance with this agreement. Obligation of the buyer to pay the broker commission shall be offset by any commission paid to the broker by either seller's broker or seller. Obligation of a seller's broker to pay a commission shall only exist if there is a prior written agreement between the seller's broker and broker, in other words, in the listing agreement that we just went over, or if the commission being offered by a seller's broker to a broker is set forth in a multiple listing service in which the both broker is a member. And then it goes on to say that you can still be paid a bonus. So what happens, I think that's it that got changed. They added again this, we've talked about this, that was in the purchase and sale. They've added this about indemnification and covenant not to sue if it's a fake seller. They added that into the buyer brokerage agreement. Okay. Let me go back here and let me skip down to these special stipulations, because the issue is what happens if your buyer finds a house they want to buy and there's no co-op commission for you? What do? Well, there are some buyers that can't pay commission. For example, if you're working with a VA buyer cannot pay commission. It's prohibited by the Veterans Administration right now, or the buyer can't qualify or whatever. It is a license law violation for you to alter the listing broker's commission, but there is nothing that says that the buyer can't ask the seller to pay commission as a special stipulation in a purchase and sale. So these are two of the new special stipulations. One is buyer requests seller to pay buyer broker's commission, VA loan. Since under the VA loan program, buyer cannot pay the buyer broker's commission, buyer hereby requests and seller hereby agrees to pay the buyer's broker blank. And that would either be a dollar amount or a % of the sale price as the total real estate commission due to the buyer's broker at closing. Nothing herein shall be interpreted as a request to alter, modify, or change the commission to be received by the seller's broker, if any, that the seller may have agreed to pay in a separate agreement. That's so you're saying you're not violating license law. And then, so that has to do with a VA buyer. And then special stipulation 620, buyer hereby requests seller to agree to pay buyer's broker, and again, a flat fee or % of the sale price as total real estate commission due buyer's broker at closing. Nothing herein is requested as a violation of license law. So this is specific to a VA loan. This can be used with any buyer. And you will remember the other thing about how a buyer's broker's commission can get paid is if the seller has made a contribution to the buyer's closing costs and the actual closing costs are less, that closing cost contribution can be used towards commission. While we're here on special stipulations, this verbiage that's in the purchase and sale, they separated it out as a special stip about these fraudulent sellers. General liability coverage, this is typically used in a commercial transaction. Buyer shall cause, no, I'm sorry. This is for inspections and inspections on a property. Buyer shall cause any person or company performing any type of testing, inspections, or evaluations. We've had a lot of issues with a buyer inspecting a septic tank and it messing up the septic tank for the seller, and they don't buy it. Buyer shall cause any person or company performing any type of testing, inspections, or evaluations of the property to first provide the seller with a current certificate of insurance evidencing that such person or company has general liability insurance and a combined single limit coverage of at least $500,000. And then this is for a temporary occupancy agreement. It is for the seller after closing, the seller to pay the buyer at closing some money to cover any damage done during that temporary occupancy. In the consumer brochure, again, the theme of everything, they've added smart home technology information. A lot of changes to the commercial. One of the new forms has to do with commercial property damage liability exhibit. This is commercial. Leases, a lot of information changed to leases. And let me just show you one more thing. On the broker-to-broker referral agreement, and we will end with this. Under the compensation to the referring broker, GAR automatically had in there 50%. Basically, it said the receiving broker pays the referring broker a certain percentage of the listing commission and bonus received by the receiving broker on any real estate commission. If it's an in-house sale and there's no other broker involved, the listing commission shall not be less than 50% of the total commission. They took that out and put it in as a fill in the blank for the referring broker and receiving broker to negotiate. And that is it. Again, a lot of changes if you do leases to leases, commercial. I have some additional verbiage in here about the commercial forms. In general, if you are a big time commercial agent, you really need to join the Atlanta Commercial Board of Realtors, and they use the Atlanta Builders Association forms. GAR works very closely with them. GAR has some commercial forms, but they're really for what they call resi-mercial agents. And it is an unfair trade practice to practice outside of your really level of expertise and training on your own. You need to get guidance, training, and a mentor or co-agent. Again, a lot of forms, a couple of the other new forms have to do with these commercial issues, maintenance and repair issues, improvements and alterations. And about seller disclosures, I just have this information in here for you, what has to be disclosed and not for when you guys download the forms. And we made it. I will stay on to answer any questions. If you do have to leave, please again type in your name, license number, email address. We have lots of other classes at that real estate at the realestateacademyofamerica.com. I've shown you a couple times where to get the forms. We look forward to seeing you in other classes. I have a YouTube channel where I cover all of this stuff more in depth in a little bit more bite-sized pieces. Please subscribe to that channel. It's called Real Estate Made Crystal Clear. And please go be a blessing with the license that you have, and have a joyous and prosperous year helping others with their real estate needs. Everybody is typing. I will stay on for questions. I thank you guys all so much. Have a very Merry Christmas and a happy, healthy, prosperous, and blessed new year. If you do have a question, because everybody is typing everything so fast in the chat, you may unmute yourself and ask a question, and then mute yourself back so we can all hear. Woo! We made it. Thank you guys so much.
Hi, this is Cassandra Sutton. I just wanted to know, does the USDA also have the loans like special stiff things like VA and FHA or not?
The actual exhibit is a little different, but a USDA loan is a type of FHA loan. So legally, federal rule wise, it does fall under the overriding FHA guidelines. But FHA and VA, they also, some of them defer to a lender. So for example, FHA, a lot of agents don't realize this. FHA guidelines call for a termite clearance letter just like VA does, but the FHA guidelines allow a specific lender to either enforce that provision of the FHA guidelines or not enforce that provision of the FHA guidelines. But a USDA loan is a type of FHA loan.
Okay, thank you.
You're welcome.
Hi, Dana. This is Valika. I had a question regarding the financial contingency and our contingency.
Okay.
So the time frame, like, what's a good rule? Because you're saying like they don't conflict, but because the financing contingency is a different time frame for the appraisal contingency if it comes in low. So I'm trying to figure out like what's the best way to do those time frames so they don't conflict. Is it like a week's difference? Should you just do the financing contingency 7 days after the appraisal?
Well, you could do them the same. You could put like 21 days from binding agreement date and 21 days from binding agreement date. The difference is the first one, the financing contingency, that 21 days in my example from binding agreement date is a drop dead time frame for the buyer. In order to protect their earnest money, they have to terminate. They have to send notice of termination before that time frame under financing, and then prove it within 7 days with a loan denial letter. The appraisal, that 21 days from financing, we have a lot of buyers, agents that think it's the same thing, and they're sending a termination notice and totally then just losing earnest money for the buyer. You could still put in 21 days, but that just means the appraisal needs to be done within those 21 days. And if it's low, the buyer has to send the amendment to the seller along with a copy of the appraisal, giving the seller the opportunity to sell it for the low price. That amendment has to be sent within the 21 days. So think of it this way. The financing contingency is an assessment of the person. The lender, how confident is the lender that if I loan the borrower this money, they're going to pay me back? So the lender does all these things. They check, well, how much money do you already owe people? How much money do you make? How good are you at paying back your bills? How much this? Okay, I'm going to take a risk. I think you're a pretty low risk. I'm going to lend you money. I'm going to lend you hundreds of thousands of dollars, and I'm pretty confident you're going to pay me back. However, in case I make a bad decision and you don't pay me back, I am going to hedge my bet, so to speak, and I'm going to take the house as collateral. So the financing contingency is the lender's assessment of how good of a risk are you that I think you're going to pay me back. Mm-hmm. The appraisal contingency is just in case you don't, I made a bad decision, I'm going to get the house back. how confident am I that the house is going to cover the outstanding debt? In case I made a bad decision on you and I get the house back, I need to be able to sell the house for the money that you owe me. So the financing contingency is an assessment of the person. The appraisal contingency is an assessment of the house as substantial enough collateral in case I made a bad decision. So they're two separate things. And so again, if the appraisal comes in low, the lender's like, fine, but I'm going to lend you less money because if I make a bad decision, I got to cover that back. So the seller, if the seller agrees to sell it for the lower price, then the lender's fine and everything's all groovy. So you have to give, in a conventional loan, you have to give the seller the opportunity to sell it for less. And that's what that time frame is that's negotiated, is just starting that conversation.
Okay. All right. Thank you.
But we still see the same number of days, 14, 14, 21, 21. To really know, you would need to call. It depends on the time of year. In the spring, for example, it's usually busier, and you would want to check with your lender, to the buyer's lender, to find out what is the time frame, what are your appraisals running. And if they're saying, oh, they're way behind, you need to put 28 days, or they're pretty good. If it's a competitive situation, put 14. If it's not, put 21, but you'll get a better number from your lender.
Okay, thank you.
My pleasure. Anybody else? No? Everybody's just staying on to hear what other questions there are. Again, if you do leases, please look at the changes GAR has made to the leases. If you do commercial, even a little bit of commercial, please look at that. Again, the other new forms really have to do with commercial. I think that's it. My pleasure. It's so good to see everybody. Yep. Happy holidays. Merry Christmas. It feels like Christmas out there today. It's freezing. Aw. I love the fireplace and the stockings and the mantle, Beth. Very cool. All right, everybody. Well, thank you guys so much. I invite you to take additional classes with me. I teach everything. I love contracts, but I teach ethics, license law, fair housing. Our school teaches a huge variety. We have a lot of closing attorneys that teach for us. They teach on estates and divorces and negotiations and new construction and all kinds of things. So please check out our calendar, www.realestateacademyofamerica.com. And check out my YouTube channel, where I have 5+ years of tons and tons of information and all that. Okay, Jenny, what is your question? You can, bye, Brent. Merry Christmas to you.
Jenny? I have
Yes.
a question. I'm in Savannah, Georgia. I had a instructor recently that I asked about the buyer brokerage agreement. There's the definition of buyer in there, and it says that it extends to spouses and any immediate family members, as well as like LLCs and stuff. What happens if the spouse hasn't signed the buyer brokerage agreement? Are they really still held to that BBA?
Yes, but well, okay, I take that back. That's just if the buyer passes away. Basically, it says, let me find it. It basically says it's really if the buyer is trying to get out of paying commission. So it's like if the buyer and the seller, or the buyer terminates a contract. So let's say it's just one spouse on the purchase and sale agreement, and they terminate the contract because they figured out, ooh, I can get this house cheaper or whatever. I don't want to have to pay commission. So they terminate the contract. Then they go back under contract under the other spouse's name or under a child's name. It's like, no. That is still you. You still owe commission. And so let me see if I can actually find the verbiage, because it talks about, it goes to family, assigns, and heirs.
It says for purposes of paying commission that it extends to them. So like, for example, if a wife signs a BBA, but the husband doesn't, and then the husband turns around and goes and signs a BBA somewhere else, what happens in that situation?
Well, you wonder why they're not talking, but that's a little bit different. Hang on one second. Let me stop. Let me answer
The
that question.
instructor that I asked here said she's never even seen that in the contract.
Let me
And-
find it 1 second. Hang on. Let me stop the recording. Thank you guys so much for watching. I hope you enjoyed this recording. If you are watching this, you cannot get CE credit just by watching this video. This is for informational purposes, but you can get CE credit by attending one of our classes. Thank you.
Dana,